After nearly 23 years in prison, Curtis Flowers tonight is a free man. All charges have been dropped. Mississippi Attorney General Lynn Fitch's office made that announcement less than an hour ago. The Winona man has faced 6 trials, 4 resulting in death sentences, and more than 2 decades behind bars for the Tardy furniture store shootings in 1996. Winona police officers found the bodies of Bertha Tardy, Derek Bobo Stewart, Robert Golden, and Carmen Rigby shot execution style. Well, it didn't take long for suspicion to land on former Tardy employee Curtis Flowers, but over the years and throughout the trials, dozens of jurors and witnesses changed their testimony. The case has been overturned more than once and ruled as a mistrial. The U.S. Supreme Court stepped in last summer, overturning Flowers' conviction. He was released on bond this past December, his first time outside of a jail cell in years. District Attorney Doug Evans, who prosecuted Flowers all 6 times, recused himself. The case has been with the state AG's office until today's announcement. The case is now dismissed with prejudice. That means he can never be charged with this crime again. In the motion, the Attorney General states there are no key prosecution witnesses alive and available who have not all had multiple conflicting statements in the record. Flowers has always maintained his innocence.
Looking forward to Christmas.
Did you think this stayed? What were your thoughts? Did you think this stayed?
I knew it would, but I didn't know when. Yeah, but I always knew it would. I don't know. I'm so excited right now. Can't even think straight. But I look forward to spending time with them and I just can't. I can't.
Thank you all very much.
Thank you all. Thank you all.
Hello, and welcome to Crime in Court. Thank you for being here. My name is Heather, and this is another Innocence Lost from my wrongful conviction series, where every week I go and introduce a new exoneree or a wrongfully convicted individual, and we talk about their case and what things went wrong and how we can learn from these situations and do much better. So as you saw in the previous clips, so you saw a news clip about Curtis Flowers, who finally was exonerated after 23 years in prison. 22, and then you saw him actually getting released on bond in the second video, and just how he was at a loss for words and how excited he was to be out of prison for the first time in 22 years after being put there for a crime that he did not commit. And this case is extremely horrific when we take a look at it and discuss it for what it is. He was basically a target of the prosecutors over and over and over again. He went to trial 6 times. As you can see from the thumbnail, it says 6 trials, 2 hung juries, 4 convictions, and now exonerated, which is amazing and wonderful that he is exonerated. But let's go back and look at what happened, what went wrong. All right, so on September 4th, 2020, the Montgomery County, Mississippi District Attorney's Office dismissed the capital homicide charges against Curtis Flowers, ending a widely publicized case that saw Flowers go to trial 6 different times, 4 of which ended in conviction, and all of which were reversed. So all of his convictions were reversed out of 6 trials. The other 2, he had 4 convictions, the other 2 led to mistrials. So, the dismissal of this 1996 quadruple homicide case from Winona, Mississippi furniture store left it officially unsolved. So, we still don't have the actual perpetrator because of the fact that they believed it was Curtis and went so full force of the law with Curtis, and they refused to look at other suspects, and a lot of their witnesses were problematic. So let's dive in. All right, so this case was a subject of a riveting podcast, and this is how I first heard about it, called In the Dark by American Public Media, that detailed how jailhouse informants who said Flowers confessed to them behind bars had recanted, as did witnesses who claimed to see Flowers on the day of the crime. Most prominently, the podcast detailed how District Attorney Doug Evans, who is white, was found to have purposely eliminated black men and women as prospective jurors in violation of federal law. You cannot do that. You cannot you cannot choose the skin color of your jurors based on the defendant in your case. So all of Flowers' trials took place outside the Montgomery County, which was a little over 50% white, and held in either Harrison or Lee counties, where the white population was more than 70%. In June 2019, the U.S. Supreme Court reversed Flowers' convictions for the homicides a fourth and final time by a vote of 7-2. Supreme Court Justice Brett Kavanaugh wrote the majority opinion and noted that in the trials, Evans used 41 of his 45 preemptory challenges to exclude black prospective jurors. Just, wow. The court held that Evans had violated Batson versus Kentucky, a landmark U.S. Supreme Court ruling that a prosecutor's use of preemptory challenge the dismissal of prospective jurors without requiring a reason for doing so could not be used to exclude jurors solely on the basis of their race, which is what he was believed to have been doing. The state's relentless, determined effort to rid the jury of black individuals strongly suggests that the state wanted to try Flowers before a jury with as few black jurors as possible, and ideally before an all-white jury, Kavanaugh wrote in his um, ruling. We cannot ignore that history because it has happened. It happened in all of his trials, and it happened in not just Curtis Flowers' trials. Surprise, surprise. He was a little shady in other people's trials too. So the homicides occurred on the morning of July 16th, 1996, at Tardy Furniture Company, a store that had been a fixture for decades in Winona, a city of about 5,800, situated about 160 miles south of Memphis. Sam Jones Jr., a retired Tardy employee, later said that 59-year-old Bertha Tardy, the store owner, called him around 9 a.m. and asked him to come in because she wanted him to help train two new employees, a 16-year-old Derek Bobo Stewart and a 42-year-old Robert Golden. When Jones arrived about an hour later, he found Tardy, Stewart, Golden, and another employee, a 45-year-old Carmen Rigby, all had been shot. Stewart was still alive. So Derek Bobo Stewart, was still alive, but he had been shot as well. The others were no longer alive. Stewart was rushed to the hospital, but on July 22nd, so when was this? The crimes happened July 16th. Sorry, I just wanted to double check. So on July 22nd, he lost his life as well. By that time, police had questioned 26-year-old Curtis Flowers, who had recently worked at the store. Flowers had caused several $100s worth of damage to some batteries that he was transporting and was told the cost would come out of his salary. He had left and did not return to the job. His hands were tested for gunshot residue and particle of residue was found. He was released after he denied any involvement in the crime. Police took his fingerprints, but his prints were not found at the scene. Police took his clothes and sent the items to the state police crime lab for DNA tests, and no evidence linked him to the crime. So, he may have had some GSR on him, which means he may have come in contact with a gun at some point in time in the last who knows how long, or someone who had come in contact with one, he came in contact with them and it may have been transferred to him. So, the fact that he had gunshot residue on his hands is not a smoking gun, no pun intended. It is really just, it could be transfer, it could be he has his own gun, who knows? So you can't just rule that as um, as if that were your only piece of evidence, then that isn't enough. But the rest of, the crime scene didn't have any fingerprints, prints of any kind, no DNA that came back to Curtis. So police found 5 shell casings that were determined to have come from a 38 caliber semi-automatic pistol. Doyle Simpson, who was Flowers' uncle, came under suspicion when he reported that a pistol of that type and caliber had been stolen from the glove compartment of his car in the parking lot of the factory where he worked. In addition to the shell casings, so you report your gun missing and you become a suspect. Okay, awesome. In addition to the shell casings, police found 2 spent bullets, 2 bullet fragments, and 1 live bullet. 3 footprints in BLOOD were later determined to have been left by a size 10.5 Fila gym shoe. There was no paper, money, no only change in a cash drawer. So it wasn't a robbery, or if it was, they took everything. Was the drawer open? Doesn't say. All right, so 6 days after the homicide, Simpson took a polygraph examination. According to police, Simpson was found to be deceptive when he said that his gun had been stolen from his car and when he said that he knew nothing about the homicides. Polygraph examinations are junk science and they don't mean anything, and cops lie. So they could say you failed even if you didn't. He lied about where he had got a gun, and police later learned he called his brother and asked him to falsely tell police if they asked that he sold the gun. If they, he told, Let me backtrack. So he lied about where he got the gun, and police later learned that he called his brother and asked his brother to falsely tell police that if they asked that he had sold the gun to Simpson. The brother refused. However, when Simpson said he practiced shooting the gun at a rural location, a detective went there and, using his knife, pried the spent slug from a post. Ultimately, the Mississippi State Police Crime Lab reported that it could not connect the spent slug from the post to the bullets found at the crime scene. However, police sought out David Balash, a retired Michigan State Police firearms expert who would later testify that he determined that the bullet from the post which was fired by Simpson's gun, had the same markings similar to the bullets recovered from the crime scene. But again, I tell you, junk science. Ballistics is junk science. You can't prove that these markings come from this gun and this gun alone. It's impossible. So it is junk science. But yet here we are, we still have people in prison that have been put away due to junk science. many people still. All right, so in August 1996, detectives led by the district attorney's investigator, John Johnson, questioned Simpson and told him that his gun had fired the bullets recovered from the crime scene. He denied involvement and maintained the gun had been stolen from his car that morning. Detectives also focused on Flowers, who had moved to Plano, Texas, to begin a new job. From the home of Flowers' girlfriend, Connie Moore, where he had been living, police recovered a box of the same size 10.5 Fila shoes. Detectives began questioning people, some of whom would later say they believed they were going to be arrested unless they cooperated, and some who would say that the portions or all of the $30,000 reward money were dangled before them. Ultimately, police got statements from a dozen witnesses who said they saw Flowers in various locations on the streets, various locations on the streets of Winona on the morning of the crime. Based on these statements, the prosecution developed a scenario that Flowers, angry over the loss of his job at the furniture store, walked across town on the day of the crime to the parking lot where he stole Simpson's gun and then walked home. He then walked back across the town, shot and took the lives of the 4 victims, robbed the cash register, so it was robbed, and then finally walked back home. On January 13th, 1997, police arrested Flowers in Plano and brought him back to Montgomery County, where he was charged with 4 counts of capital homicide. He was named in 4 separate indictments. A defense motion to consolidate the cases was denied. Because of the extensive media coverage, one of the trials was moved from Montgomery County to Lee County. The trial was only for the homicide of Bertha Tardy. The prosecution planned later trials for the other victims. Flowers went to trial in October 97 before an all-white jury. District Attorney Evans used all of his preemptory challenges to strike prospective black jurors. By that time, the prosecution had 2 more witnesses. Frederick Veal and Maurice Hawkins both testified that Flowers admitted committing the crime to them while they were cellmates when Flowers was awaiting trial. Veal said Flowers confessed to the homicides and to taking money from the store while they were playing dominoes. Hawkins said the confession came while they were playing solitaire. Patricia Hallman, a neighbor of Flowers, testified that at about 7:30 a.m. on the morning of the crime, she saw him going into his house in a rage. Other witnesses testified they saw him at various points that morning. Catherine Snow testified that she saw Flowers leaning against a car outside the Angelica Garment Factory where Doyle Simpson worked and where he said someone stole his gun from his unlocked car. Clemmy Fleming, oh, that's a name, Clemmy Fleming, testified that she got a ride from Roy Harris to go to the furniture store at 10 a.m. to make a payment on her bill. However, she said that she didn't go in because she was pregnant and feeling sick. She said so she asked Harris to drive her home. She said that she saw Flowers running away from the store. Harris testified that he did see someone running and that Fleming had said it was Flowers. Okay, so he didn't know who it was. Jack Matthews, an investigator for the Mississippi State Highway Patrol, testified that based on a ledger sheet found in Tardy's, approximately $287 was missing from the cash register. The prosecution theory was that the $255 found in Flowers' girlfriend's home was from the furniture store. How can you be sure of that? Like, that is because she had cash. Wow. Okay. A forensic analyst who analyzed the gunshot residue test conducted on Flowers testified that the residue was from handling a gun to the exclusion of all other environmental sources, which is also junk science and a bunch of malarkey, if you ask me. Baelish, the firearms expert, testified that he was positive that the bullets recovered from the scene had been fired from Simpson's gun based on his comparison with the bullet pried from Simpson's target practice post. It has to be 100% or I will not offer that opinion, he says in testimony. Flower's girlfriend, Connie Moore, testified that she had purchased the box of size 10.5 Fila shoes for her son around November 95. She said her son had gone to live with his father in January of 96 and took the shoes with him. Flowers testified that he began working for Bertha Tardy sometime in early July. He had been told when he was hired that any damages he caused would come out of his paycheck. He said that he picked up some batteries and they fell out of his truck while he was driving. When he told Tardy about she said that if they could not work out anything about the damages, it would come out of his check. He said he had not received a check, but had previously been advanced $30. Flowers said he did not go back to work after July 3rd, but he did call in and Tardy told him she had hired someone else. Flowers said that on the day of the crime, he got up around 9 a.m. and while cooking, cut his hand on a can of shortening. He said he went to his sister's house to get a bandage and then went to the convenience store to buy beer and chips. Flowers denied committing the crime. He denied stealing the gun from Simpson's car and denied running near the store near 10 a.m. He said he wore a size 11 Nike brand shoe. He said he had shot off fireworks the day before the homicides and also had handled a lead car battery while working on his truck. So maybe that had something to do with the gunshot residue, the lead battery in his truck. On October 17th, 1997, after an hour of deliberation, the jury convicted Flowers of the homicide of Bertha Tardy. The same morning, following a sentencing hearing, the jury imposed the D penalty. While that conviction and sentence were being appealed, Flowers went to trial for the homicide of Derek Bobo Stewart. And remember, he's the one that was found alive but later died from his injuries. This trial was moved to Harrison County. Prior to the trial, during the defense motion to bar the testimony of the jailhouse informants Veal and Hawkins, Veal recanted his testimony. He said he had been coerced by the prosecution and promised a share of the reward, the 30 grand reward money. Hawkins stood by his testimony, although the defense confronted him with an undated transcript of an interview during which Hawkins said that he never talked to Flowers in jail. In that transcript, Hawkins said he testified against Flowers to protect myself from doing time and getting KILL'd. He said a illegal substance charge against him was dropped and he got house arrest for burglary in exchange for his testimony. And this, my friends, is what happens all the time when the prosecution needs a little boost in their case because they don't have enough to convict this individual on the evidence alone because it doesn't point to that person. So they get someone who has priors and they make a deal with them and say, we'll make those charges a little bit easier for you if you cooperate and testify. Tell me what I want to hear. It happens all the time. This is prosecutorial misconduct, and it happens all the time. It could be anywhere in this country, anytime this could be going on, and we need to be paying attention. That's why it's so scary. The second trial, so that was just the first trial, and that was just one of the individuals. So now the second trial began in March 99. The racial makeup of the jury was 11 white members and 1 black member. There were a few differences at this trial. Roy Harris had testified at the first trial that he was with Clemmy Fleming at 10 a.m. near the furniture store when they saw a man whom Fleming said was Flowers running away from the store. He now testified that he saw a man running in downtown Winona at 9 a.m. and that Fleming was not with him. Harris said that an hour later, Fleming asked him to take her to the furniture store, but she changed her mind and they turned around before they ever got there. Interesting that he changed his story so oddly. In addition, Latarsha Blissett and Stacy Wright, Fleming's cousins, both testified that Fleming admitted to them that she had not seen Flowers running from the store. That's why they didn't put Clemmy back on the stand, and had Harris testify for her. That's why, because she admitted to people that it wasn't Flowers. Wow. All right. So, and Fleming's sister, Mary Ella Fleming, testified that when Clemmy Fleming arrived at her house on the morning of the homicides, a friend came to tell them that Bertha Tardy had been KILL'd. Mary Ella Fleming testified that she and her sister went to Tardy's, but that Clemmy Fleming never mentioned anything about having seen Flowers earlier that morning. Interesting, right? So where did Clemmy get that from? And where did she even come from if she wasn't even there? The defense also called Odell Hallman Jr., the brother of Patricia Hallman, who had testified that she saw Flowers on the day of the homicides. Odell, who was in Parchman Prison on a probation violation for aggravated assault, testified that Patricia was lying and that she was doing it at his suggestion in an attempt to cash in on the reward. So they wanted the reward money. So they were lying. That was their little scheme. All right, so on March 30th, 1999, the jury convicted Flowers of capital homicide. The following day, they voted to impose the D penalty again. Poor guy. And it's like years apart, these trials. In December 2000, the Mississippi Supreme Court reversed Flowers' first conviction. So now it's been reversed, a new trial's happening. The court did not address the defense claim that Evans had improperly excluded Black prospective jurors. The court held that Flowers' trial was unfair because the prosecution was allowed to present evidence of all 4 homicides, not just the homicide of Bertha Tardy. As a result, the jury was exposed to inflammatory and prejudicial evidence, the court ruled. In addition, the court said that Evans repeatedly asked improper questions not in good faith, in which there was no basis in fact. The prosecutor also improperly argued a supposedly inconsistent statement made by Flowers to law enforcement by admittedly holding up a taped statement which was not in evidence at the time and in fact was never introduced as evidence to show inconsistencies as alleged or on the particular date claimed by the prosecutor. So he's citing evidence that never even made it into evidence. Awesome. This potentially became confusing and misleading to the jury, especially when coupled with improper cross-examination of Flowers and an improper comment by the trial court. In April 2003, the Mississippi Supreme Court reversed Flowers' conviction for the homicide of Derek Stewart. The court said it was absolutely compelled to find that the state employed a tactic of trial strategy of trying Flowers for all 4 homicides during this trial, for which he was indicted only for the homicide of Derek Stewart. So they brought in all the other evidence of all the other. If you're going to try him, if it's just for the one count, the one person that they're going to have the charges on for Derek's Bobo Stewart, then you can't bring in all the evidence of the 3 other individuals from the homicide. You can't have it both ways. So evidence of the other victims was admitted through photographs, diagrams, and other testimony, which was neither relevant nor necessary to prove the state's case in chief against Flowers for the homicide of Stewart. By using this tactic or trial strategy, the state improperly prejudiced the jury and denied Flowers his fundamental right to a fair trial. The court, as it did in the first reversal, also found that the prosecution repeatedly argued facts not in evidence. This occurred during the cross-examination of several witnesses and during the closing arguments of both the district attorney and the assistant district attorney. At that point, the prosecution consolidated all 4 cases, and Flowers went to a third trial in Montgomery County. Seriously. In February 2004, at least now the cases are consolidated, geez. During jury selection, the prosecution used its first 7 preemptory challenges to strike black jurors. The defense objected, contending the strikes were racially motivated. The prosecution then used its remaining 5 preemptory challenges of potential jurors on black people. So they continued to do it. Ultimately, the jury of 11 white members and 1 black member was selected. The lone black juror was selected after the prosecution ran out of preemptory challenges. At the end of the jury selection process, the trial court ruled that the prosecution had not exercised its preemptory challenges in a racially discriminatory manner. The trial court, so the court that was presiding in that trial. So this trial unfolded similarly to prior trials with a notable exception. Odell Holman Jr. testified for the prosecution that while at Parchman Prison, Flowers confessed to him that he committed the homicides. Holman became the 3rd jailhouse informant to claim that Flowers had confessed. So they're coming out of the weeds, these jailhouse informants. On February 11th, 2004, the jury convicted Flowers of 4 counts of capital homicide and sentenced him yet again to the deep penalty. 3 years later, on February 1st, 2007, the Mississippi Supreme Court reversed the convictions and ordered a new trial. So, again, it's going to the Supreme Court and it's getting overturned. The court held, like, what a roller coaster ride. Can you even imagine Curtis Flowers, how he feels this whole time? Like hope and losing hope and no hope and his family members. And I mean, it's just insane. No human should have to go through this. I thought we were supposed to be a civilized country. So 3 years later, on February 1st, 2007, the Mississippi Supreme Court reversed the convictions, ordered a new trial. The court held that the prosecution had engaged in racially discriminatory jury selection yet again. The court said the case presents us with a strong prima facie case of racial discrimination as we have ever seen. So it is like the standard of all racially discriminatory jury selection cases ever. It's the boilerplate for it. It's pretty bad. Flowers went to trial a 4th time in November 2007. The jury consisted of 7 white and 5 black members. Okay, so getting a little better. On December 5th, 2007, a mistrial was declared when the jury was unable to reach a verdict. Oh, look at that. You bring in a couple more black people and it's not so easy to reach a consensus. There might be, a little less pressure and pushback, or more pressure and pushback, I should say. All right, so the jury deadlocked, tracked racial lines with 7 white jurors voting to convict and 5 black jurors voting to acquit. The 5th trial began in September 2008. 9 white jurors and 3 black jurors were impaneled. On September 30th, this trial also ended in a mistrial with jurors voting 11-1 to convict. The lone holdout juror was black. This is why it's very important that you don't just strike someone down because of their race. In the summer of 2010, Flowers went to trial for the 6th and final time. 11 jurors were white and 1 juror was black. On June 18, 2010, the jury convicted Flowers of 4 counts of capital homicide, and he was again sentenced to the death penalty. Flowers, represented by Key Wable, an interesting name, Keir Wable and Sherry Johnson from the Cornell Law School D-Penalty Clinic, and as well as Allison Steiner, who defended Flowers at his fifth and sixth trials, appealed. In 2014, the Mississippi Supreme Court upheld the convictions and the D-penalty sentences. Flowers' legal team sought review in the U.S. Supreme Court, and in 2016, the court ordered the Mississippi Supreme Court to review whether the prosecution had again engaged in racially discriminatory jury selection. Why are we allowing them to continue to do it? Like, why are we giving them that many times to try this man? This is awful and horrific. In November 2017, the Mississippi Supreme Court ruled by a 5-4 vote that there was no discrimination. Really? Mississippi Supreme Court said that, even though all those other times they did say that. Flowers appealed to the Supreme Court again. While the appeal was pending, American Public Media, APM, conducted an extensive investigation of the case and broadcast their findings in the podcast In the Dark, which began in May 2018. During the APM investigation, Clemmy Fleming said her testimony in all of Flowers' trials that she saw him running away from the furniture store at about 10 a.m. on the day of the crime was untrue. The whole time I've been telling them I don't remember the day, Fleming said. I've been confused of the day from the beginning. I just didn't know how to say it. I was scared and I was going to go to jail. Odell Holman also recanted calling from a contraband cell phone from prison where he was serving a life sentence for a triple homicide committed in 2016. As far as him telling me he KILL'd some people, hell nah. He ain't ever told me that. That was a lie. Holman said in the APM episode, like he called on a contraband cell phone to talk on this podcast. It was amazing. I don't know nothing about this. It was all make believe. Everything was all make believe in my part. So obviously, this podcast was happening while Curtis Flowers was still in prison. So all this stuff was still unfolding as they were unraveling this case, and eventually, as they were still doing seasons of it, they were. He was eventually exonerated while they were in the middle of completing it. So they did complete it with the last season of his exoneration. All right, so where was I? All right, so Hallman claimed that the district attorney Evans dropped illegal substance charges pending against him and provided Hallman with assistance in other cases that resulted in no prosecution at all. So he just got off scot-free on some other charges here. Evans denied that he ever helped Hallman. So Evans is a big fat liar. APM attempted to track down the root witnesses, those individuals who said that they saw Flowers at various places on the morning of the crime. Harris, who had recounted his testimony at the second trial, said that when people first showed him a photo of Flowers, he said that the man that he saw running down the furniture store from the furniture store was not Flowers. So once he saw a picture of Flowers, he said, "Nope, that was not the man that I saw." Eventually, he broke down and said it was Flowers because he was afraid that the police were going to arrest him if he didn't identify Flowers. So not only do you have some prosecutorial misconduct, you got some law enforcement misconduct going on in this case. Edward McChristian recanted his testimony that he was sitting on his porch and saw Flowers walk past his house going away from the Angelica factory sometime between 7:30 a.m. and 8 a.m. He told APM that he had no idea which day he saw Flowers walk past his house, and he didn't know whether it was the day of the homicides or a different one. McChristian told APM that he didn't want to testify at Flowers' trial, but he worried that he might get fined or even put in jail if he refused. In June 2019, the U.S. Supreme Court reversed Flowers' convictions and death sentences, ruling that the prosecution had engaged in racially discriminatory jury selection yet again. But now this was the U.S. Supreme Court ruling, not the state. So, U.S. Supreme Court, Trump state. So he gets his convictions overturned. And he almost got tried a seventh time, by the way, but luckily that did not happen. All right, so in the sixth trials combined, the state struck 41 of the 42 Black prospective jurors it could have struck. So out of the 42 that it could have struck, it struck 41. Wow. So the other ones that did sneak on the jury, that means they ran out of strikes. They ran out of strikes, and that's how others got on. Sick, disgusting behavior. All right, at the sixth, and I'm not gonna lie and say, pretend like it doesn't happen where you hope to get someone maybe with their race just because potentially you think that they might have more in common and can relate more with your client. So it's not unheard of to do this, but that can't be the only reason why you strike someone for being on a jury. All right, so at the sixth trial, moreover, the state engaged in dramatically, wait, did I? At the sixth trial, the state struck 5 of 6. At the sixth trial, moreover, the state engaged in dramatically disparate questioning of Black and white prospective jurors, meaning they asked them different things, totally different questions. And it engaged in disparate treatment of Black and white prospective jurors. So obviously they were treated differently and asked questions differently. That's not cool. Attorney Sherry Lynn Johnson from the Cornell Law School, who had made the argument in Flowers' case that led to the reversal, said that the case should be dismissed, that Mr. Flowers was already endured 6 trials and more than 2 decades on D row is a travesty, she said in a statement. A 7th trial would be unprecedented and completely unwarranted, given both the flimsiness of the evidence against him and the long trail of misconduct that has kept him wrongfully incarcerated all these years. We hope that the state of Mississippi will finally disavow Doug Evans' misconduct, decline to pursue yet another trial, and set Mr. Flowers free, according to Johnson. Meanwhile, the Washington, D.C. law firm of Hogan Lovells and Tucker Carrington, director of the George P. Cochran Innocence Project, the University of Mississippi School of Law, where law students worked on developing evidence of racial bias during jury selection, as well as the Mississippi Office of Post-Conviction Counsel and attorneys Rob McDuff and Henderson Hill, began preparing for a possible retrial in the case. They asked that Flowers be released on bond. On December 16, 2019, Flowers was released to home confinement to await a 7th trial. In January 2020, District Attorney Evans stepped off the case. So he finally recused himself. And the Mississippi Attorney General's office began reviewing the case. So the AG's office took over as soon as the DA goes bye-bye. On September 4th, 2020, Mississippi Attorney General Lynn Fitch announced that the charges were dismissed, and that was with prejudice. They can no longer come at Mr. Flowers ever again for these crimes. In a statement, Flowers declared, "Today, I am finally free from the injustice that left me locked in a box for 23 years." In March 2021, the state of Mississippi agreed to pay Flowers, $500,000 in compensation, the maximum allowed at a rate of $50,000 per year over 10 years. Thank goodness he's getting something for it. And in September 2021, Flowers filed a federal civil rights lawsuit seeking damages from Evans and police officers in this case. And it is about damn time that we start holding law enforcement and prosecutors and judges accountable for the crap that they do. That's illegal and just unethical, wrong. This, my friends, is the face of Doug Evans. So this is an article that I found. It was written in January of 2019. So at this time, he still technically was the DA, but I thought this was an interesting article because it talks about, will Doug Evans face accountability? So let's talk a little bit. So the man most responsible for Flowers' ordeal, District Attorney Doug Evans, has faced no adverse consequences for his handling of the case. Evans is still, well, he has since resigned and he recused himself from that case and then he resigned shortly thereafter. So he's not the chief prosecutor for, or he's not prosecuting Flowers, but he is still the chief prosecutor in 7 central Mississippi counties. He was reelected in November 2019 to another 4-year term, running unopposed. Last month, a civil rights lawsuit filed against him over his jury selection practices was thrown out by a federal judge. Well, what do you know? The judges trying to pat the other people of law, brother. Do you call like a fellow? I know you can call like your fellow attorney a brother, but I don't know what does a judge call their fellow attorneys? I mean, I know they're not of the same. I don't know what I'm saying. Never mind. ADHD. All right, so Evans is still the chief prosecutor, blah, blah, blah. Last month, the civil rights was thrown out. According to the Mississippi Bar Association, Evans has received no public sanction and is still a lawyer in good standing. Evans couldn't be reached at his office for comment, and this is the crap that pisses me off. You do this to somebody, you do this to one individual, you're probably doing it to more. So why are we allowing him to continue to practice law and to prosecute people when he's obviously been proven that he cannot do the case or he cannot do the job of a prosecutor without major prejudices and biases? It shows how flawed the system is, said American University Washington College of Law professor Angela J. Davis, who researches the power of prosecutors. Full disclosure, Davis has donated to In the Dark. Evans is not an exception. He's just an extreme example of what's really wrong with the system in terms of holding prosecutors accountable. Prosecutors have enormous direction to pursue criminal cases as they see fit. Their actions in any individual proceeding can be reviewed on appeal, but their overall conduct is rarely subject to oversight. In the Flowers case, courts have repeatedly found that Evans flouted the Constitution. 4 of Flowers' convictions were reversed on appeal, all because of Evans' misconduct. Yet, he was allowed to retry Flowers again and again. And other people, not just Flowers. There's other people, like he should have been recused from the case, obviously, like long before, or kicked off the case if he wasn't going to recuse himself. During oral arguments before the U.S. Supreme Court in March 2019, the justices took issue with Evans' pattern of striking Black prospective jurors in Flowers' trials. Several commented on the distressing history of the case. Justice Samuel Alito, one of the High Court's more conservative members and former prosecutor, twice asked the state of Mississippi's lawyer how Evans was allowed to keep pursuing Flowers and why the Attorney General's office hadn't stepped in. That's a great question. Just like, let's keep going after Karen Reed, even though she's factually innocent. Let's just keep going after her. Why hasn't the AG's office stepped in yet? I think they will. I think they're going to. All right. Well, could we say in this case, because of the unusual and really disturbing history, this case just could not have been tried the sixth time by the same prosecutor, Alito said. Assistant Attorney General Jason Davis, there to argue that the justices shouldn't overturn Flowers' most recent conviction, didn't attempt to defend Evans' conduct over the years. So the ADA, or I'm sorry, the Attorney General, the Assistant Attorney General was there, but to say that, to say, hey, don't overturn the conviction. He should remain in prison, but you know what? I have no excuse for Evans. Like what? You're saying Evans was conducting misconduct and yet keep Flowers in jail, please. The history in this case is troubling, he said. And it lacked the legal authority to take over a case unless the prosecutor requested it. In other words, Evans would have to remove himself. So that's another problem. The AG just they didn't want to touch it. In June 2019, the Supreme Court, in a 7-2 ruling, overturned Flowers' 2010 conviction, finding that Evans deliberately struck black jurors at the sixth trial. The majority was unsparing in its criticism of Evans' conduct. Justice Brett Kavanaugh wrote in the opinion that Evans was motivated in substantial part by discriminatory intent, and his relentless, determined effort to rid the jury of black individuals strongly suggests that the state wanted to try Flowers before a jury with as few black jurors as possible, and ideally before an all-white jury. Two other courts had previously ruled that Evans had committed the same type of constitutional violation in Flowers' case. So we knew that this was happening, and then this third time when it happened and they tried to appeal it to the Mississippi uh, Supreme Court, they said no. He was unethical and prejudicial in his selecting the jury in the other two, but not this third time? What? Okay. And an analysis by the In the Dark had found that Evans and his assistant district attorneys, over 26 years of trying a variety of defendants, struck black prospective jurors at nearly 4.5 times the rate they struck white ones. That is another picture of Oh, that's a picture of Doug Evans with witness Clemmy Fleming during the sixth trial in 2010. I didn't want to read this whole story about uh, all the details that there was here. Okay. Yeah, so we went through all of that, but oh, here we go. Yeah, so we went through all of like the details of the case already for Curtis Flowers. That's all I was skipping there. But I just wanted to read this portion about district attorneys. So because district attorneys in Mississippi and all but 5 states are elected, Evans can't be fired and he has no boss to reprimand him if he breaks the rules. And voters often have no power at the ballot box. A 2009 study by Ron Wright, a law professor at Wake Forest University, found that in 10 states over a roughly 10-year period, 85% of incumbent district attorneys ran unopposed, and when they did face a challenger, won 69% of the time. That's horrific. In jurisdictions with small legal communities like Evans, taking on an incumbent district attorney only to lose isn't worth the risk for many lawyers. Yeah, I mean, it costs money to run, and if you know you're going to lose anyways, why even bother? In most other countries, prosecutors are appointed. I don't know. I don't know what's better, voting or appointing, because they could be appointed by corrupt people in power too. So it really doesn't matter. I think either way. Sorry, my notebook fell. I bumped it. All right. And though Evans is bound, like all lawyers, by his Bar Association's code of conduct, that code is broad and loosely enforced. Bar associations use disciplinary measures to censor private practitioners who steal their clients' money and to purge from the profession attorneys who are themselves convicted of felonies. The rare, they rarely punish prosecutors, even in cases in which their misconduct violates the Constitution and results in the reversal of conviction. Prosecutors also have absolute immunity from lawsuits seeking money damages. In November, which is bullshit. Sorry for my French, but I don't think anybody should have immunity. Nobody. I don't care what your job is. Nobody should have immunity. Everybody makes mistakes and everybody is everybody has the let's say let's say it this way. You have a 50-50% shot of doing the right thing or doing an unethical thing. Okay, 50-50. And I don't want to take that risk. I don't think you should be immune. 50-50, whether you're a good person or a bad person in whatever profession you're in. You know, anybody could be unethical or ethical. That doesn't you need to um by allowing immunity, you are allowing more corruption and more people who are unethical to run to those positions because they can take advantage of others and use their power and authority for their own benefit. Anyways, all right. So in November 2019, lawyers from the NAACP Legal Defense Fund and MacArthur Justice Center filed a federal civil rights suit against Evans on behalf of his Black constituents. The suit sought only a court order forcing Evans to stop his practice of striking Black prospective jurors at a disproportionately high rate. That's crazy. So they put together this lawsuit in order to get him to stop striking down Black prospective jurors. It was a novel tactic that attempted to create a template for prosecutorial oversight moving forward. But of course, the suit was dismissed by an Obama appointed judge who, while noting that the claim of Evans' racial bias seems to be true, ruled the federal courts shouldn't interfere in state criminal proceedings. That's not interfering if you're making people remain ethical and going above board. See how messed up our system is? Criminal justice experts say there's no one reform that can hold prosecutors to account. It takes a lot of things, said Bruce Green, a Fordham Law School professor and former prosecutor. It takes trial judges to do their job and inquire into cases where the prosecutors might not be acting properly. But that means you have to have a judge who knows what they're doing, is good at their job, and is ethical as well. And we don't always have that. It takes the trial judge to do their job. It requires disciplinary authorities to be more robust. It requires legislators to look at the law. It requires elected prosecutors to conform to their ethical obligations. And it requires the press to look into what prosecutors are doing and write articles about prosecutors who look like they're going astray. I love that. Hold them accountable in many forms and fashions. It was only after Flowers' case received national media attention and was reviewed by the Supreme Court that Evans finally agreed to surrender the case. What do you know? After 23 years. Sick. Green said more scrutiny has and will continue to lead to more accountability. As long as the public cares, things are going to move in a positive direction. If you take the long view, things get better. Asked by In the Dark if there was anything he wanted to say to Evans, Flowers said no. There are some things that just don't need to be said. What's understood is understood, Flowers said. I feel that Doug was wrong, and he knew he was wrong. Flowers lost 23 years of his life to prison, years he will never get back. The Tardy Furniture homicides remain unsolved. The families of the victims have received no justice and no closure, and K.I. Double Eller may still be on the loose. In the eyes of the law, Curtis Flowers' case has been remedied, but the flaws in the criminal justice system have not. Evans has been back in court prosecuting cases as he has for 29 years. Oh my God, these people. The law changes and times change, but these people don't change with it. And the law doesn't change very quickly, and they're part of the problem. All right, so Davis, the American University law professor, says that's why prosecutorial accountability matters. Curtis Flowers is not the only person this has happened to. It's happened before, and it's going to keep happening, she said. Accountability matters because there is another Curtis Flowers that you just didn't discover yet. I added the yet. And finally, on a good note, Doug Evans has retired. Finally. Woo woo. So this was an article written July 12th, 2023, announcing basically that he retired. There's really not much more that I can read or add to what we've already talked about, but basically yeah, so this is repetitive. I don't want to read through same old stuff, but oh, I did read that. About the 4.5 times. Sorry, I thought that was a different fact. All right, never mind. Basically, all DPIC's Prosecutorial Accountability Project has uncovered at least 68 death sentences which were overturned due to jury discrimination. Interesting. I might have to look into that, this Prosecutorial Accountability Project. So that is pretty much where I leave you. I just wanted to let you know that yes, he retired, he recused himself from the case, and then shortly thereafter retired. Mr. Evans' retirement coincides with the Supreme Court's decision not to review the conviction and sentence of Tony Clark, another black man sentenced to D penalty in Mississippi, who has also alleged, that's what I wanted to read you. I had so many articles open, sorry. So basically, this Doug Evans guy, before he did retire, there were multiple other cases where this being the one that the Supreme Court decided not to review. Another black man sentenced to the D penalty in Mississippi, who also alleged that the prosecutor in this case discriminated against black jurors during jury selection. Same thing. The Justice Sotomayor wrote that this can only be read as a signal from the Mississippi Supreme Court that it intends to carry out with business as usual, no matter what this court said in Flowers. So basically saying, like, you guys totally ignored us with the whole Flowers comments when we told you you guys need to stop striking jurors based on their race, but yet they continue to do it. So this was basically her yelling at them, telling them, like, you guys didn't listen. So by allowing the same court to make the same mistakes, applying the same standard, the court acquiesces in the Mississippi Supreme Court's noncompliance. Today, this court tells the Mississippi Supreme Court that it has called our bluff and that this court is unwilling to do what is necessary to defend its own precedent. The result is that Flowers will be toothless in the very state where it appears to be still so needed, meaning it'll be the Flowers case and all the strides that it did make, it's going it all the strides that this case did make going forward for the justice system, it's going to take us backwards if we're just going to ignore it and continue to just be racist and strike people for their race and skin color, which is ridiculously stupid. So we all know that. Anyways, that's where I leave you guys. So thank you guys so much for watching. Please hit the like button. Let me know what you think about Doug Evans. What a creep. And the Curtis Flower case and how and what you think about 23 years in prison and 6 trials, 4 convictions, 2 hung juries, and 1 really awful prosecutor. It's pretty bad. How many times is too many times that a prosecutor can keep coming at someone over and over again? I think there needs to be a limit. What do you guys think that limit should be? Let me know in the comments below, and I will see you guys in the next one. Please hit that like button on your way out. Thank you. Have a good one. Bye now.